Okay. Well, welcome everyone. My name is Taisha White and I run the Employer Advocacy Program at the DC Chamber. And today we're going to dive into the world of unemployment insurance. So I see we got some light rain today, so I'm very glad that we decided to do this as a virtual event. If I can get a sense for who's in the room, please. Introduce yourselves.
All right, my name is Lucky Ames. I'm with the DC Chamber of Commerce. Good afternoon, everybody.
Thank you, Lucky. I see a Don Martin.
Hello. Yes, I'm Don Martin. I'm the Event and Operations Specialist here at the DC Chamber of Commerce as well.
Great. And then I see Ebony Johnson.
Hello, good afternoon. I'm Ebony Johnson. I'm with the Chamber as well as an executive assistant.
Awesome. I'm sorry if I don't want to say this wrong. Is that Shalani?
Hi, good afternoon. This is Shalini Devasahayam from TechFlex, a CPE in the district.
Awesome. Welcome. And then I see Vanessa.
Hi, this is Vanessa Wen, and I'm with the Ford Agency.
Great. Thank you. I'm sure other people will trickle in. I don't necessarily plan to go back and introduce them, but I like to get a sense for who's in the room. When I present, I do like for things to be interactive. So if you have a question about anything that I discuss, please feel free to go ahead and just raise your hand or drop a question or comment in the chat box and we can discuss it in real time, okay? So with that, let's get started. So again, I am Taisha White. I run the Employer Advocacy Program at the DC Chamber, which is a government-sponsored contract from DOES, which is Department of Employment Services. And so my role is to provide free legal representation to employers dealing with a DC unemployment claim at the appeals level. So we're going to talk a little bit later about the different steps that are involved in an unemployment claim that I think most people just are not necessarily aware of. I am originally from North Carolina. However, I am a proud DC business owner and homeowner. I've lived in the district for almost 20 years. August will make 20 years. I graduated with honors from Howard University School of Law, and then I clerked for a federal judge right out of law school. So I have a unique ability to think as the judge would in a case and to present the case in a way that I think it's the judge often will find compelling. After 12 years in working in big law firms, I opened my own law firm practice where I also focus on estate planning, which is a passion area of mine. All right. So today we are going to talk about unemployment, and I want to start with just an overview of what unemployment is, because I noticed that in working with a lot of my employer clients dealing with appeals, there was a lot of kind of confusion about what the different agencies were, what is the purpose of unemployment, just kind of feeling generally frustrated with the entire process. So I thought, well, let's just kind of start with the basics, do a refresh of the fundamentals of how unemployment insurance works. And it's very understandable because DC has lots of acronyms. So it gets very confusing when we talk about DOES, OAH, the various acronyms in the DC government. And there are a lot of misbeliefs about unemployment that we're going to talk about some today. So with that, let's talk about what we're going to cover today. First, we're going to talk about the goal of this training. Then we're going to also go over some myths and facts about unemployment. Next, we'll go over what are the requirements for an employer as it relates to the unemployment system. And then we'll also go over the eligibility requirements for an employee to even be able to apply for and receive unemployment. And then we're going to briefly discuss the anatomy of an unemployment claim. We will reserve specific details about the actual grounds for disqualification for another training session. And then we'll wrap it up with a summary and allow for you all to ask questions. All right. So let's go over some the training objective. The goal really of this training is to basically introduce you to the unemployment system in DC, We're only focusing on DC for this training. Each state has their own set of rules and processes related to unemployment. We're solely focusing on DC for this particular session webinar. And I do need to just say, as a lawyer, this is not legal advice. This is an educational webinar. So, definitely consult with your lawyer for specifics of your situation. But basically, I want to make sure you walk away with a basic understanding of what are the requirements for the employer as it relates to registering for, reporting, and responding to unemployment claims, as well as to give some insight on ensuring that you're doing enough to be compliant with unemployment and therefore able to safeguard your rights as it relates to this. All right, so let's go over some myths and frustrations that I've kind of been hearing. So the first and the primary is that people think that unemployment is basically to award employees and penalize employers. Anybody heard of that or had that kind of reaction to unemployment? Talk to me, please.
No.
No, okay, good. Okay, well, good. You guys are good on that. A lot of people just kind of feel like, they're being penalized in some way if an employee receives unemployment. Unemployment, however, is a statutory right across the country, and it's one of the most successful programs coming from the Social Security Act of 1935. So shortly after the Great Depression, of course, there were a lot of programs to try to, address societal needs, to restabilize the economy. And the unemployment insurance program was one of those. And so it has been touted as one of the more successful programs in kind of minimizing periods of, I guess, economic instability in the country. The purpose of unemployment is to protect against economic dependency on other social welfare programs. Employers pay into the unemployment system, and then their former employees can receive some compensation, but only when the employee is not at fault. So we're going to talk a little bit later about what that means for an employee to be not at fault. Conversely, if an employee has engaged in certain behavior that causes their unemployment, they will not receive compensation. So unemployment is not really about a tit for tat of, who was right or wrong in terms of the termination. It is a statutory right. And then there are statutory rules governing when an employee can and cannot receive this statutory right. Myth number 2 that I hear from people is that they think that the DC government is somehow benefiting from taxing employers for unemployment taxes. Reality is that the funds that an employer pays for unemployment taxes does not go into DC's general purpose funds. So it's not used for DC, other components of DC. It is the funds are deposited with the U.S. Department of Treasury and to, a particular unemployment trust account. And then each employee has their own account. And so all of their funds are accounted for within this account. And then when an employee gets or receives unemployment compensation, those funds come out of the employer's amount that they've deposited. And then last myth that I'm really hearing is that there's no point in challenging an unemployment claim because people believe that the employer will automatically lose and that, everything is leaning towards the employee. And so while it is true that because this is a statutory right for employees, there is some leniency towards or leaning towards employees. The employer can actually win and succeed in disqualifying someone from unemployment. However, they need to be proactive. So, for instance, you can actually, as an employer, be forbidden from seeking certain unemployment related relief. So for instance, if you've overpaid into unemployment insurance, if you have consistently not been responsive to unemployment claims. So you need to be responsive when you get a request for information, because If you don't, that can count against you. Also, if you are properly documenting the reason for the reason for the separation or ending of the person's employment, you actually do have grounds to at least present and make your case for why the person should not receive unemployment. Any questions on this particular slide? No? Okay. All right, so what are the requirements for an employer? Okay, so first, you have to have at least one employee that is performing services in DC. So if you are a solo business, you don't have any employees, you do not have to register. However, if you've got just one employee, whether they work full-time or part-time, you are required by law to register for unemployment taxes. And I've included the website there for where you would go to register. Little known fact is that also across the country, but in DC, if you have domestic workers in your home and you pay at least $500 a quarter, so every 3 months, then you also are required to register for unemployment tax. And then you are assigned a 6-digit unemployment tax account number. Next requirement is reporting. So on a quarterly basis, the employer is required to report to the Department of Employment Services how much in wages they have paid for that quarter. In a minute, you'll see the timeline for reporting requirements. If you do not report timely, you are subject to both interest and penalties. So there's a 1.5% interest on the wages that you report. And then there's also a 10% penalty. So you do want to keep those dates in mind, put them in the calendar, and do your reports timely. And then there are also some reporting requirements, and this is definitely striking us more post-pandemic as more employees work from home, especially with us being in a DMV situation, so people can work in one state but live in another, and so now they're working from home and they may be working in other states. We'll get into the formula in a minute for dealing with employees that do not work exclusively within the district. And then also you are required to report new hires within 20 days. And that can actually be important amongst employers because, we can help each other out by making sure that someone isn't receiving unemployment when they've actually got another job. But there's no way for the Department of Employment Services and or the former employer to know that unless it's reported. So there's the website there, dc-newhires.com, for you to report hiring a new employee. The next thing is that you have to pay state and federal unemployment insurance taxes. For DC, it's the base rate of 2.7% of the wages that you're paying your employees or your experience rate. And so that's going to be a topic that I want to try to put forth a little bit later is having DOES fully explain what the experience rate is and how that, how getting claims for unemployment impacts the base rate that employers have to pay. But suffice it to say, we start at 2.7%. If that increases, you'll get a yearly notice if your unemployment base rate tax has increased. And then for DC, you stop paying unemployment wages once, you've hit 9,000 in wages per person. So other states, you pay unemployment taxes up to a higher amount of wages. So DC actually is pretty, I guess, more, I don't want to say lenient, but gracious, I guess, to employers when it comes to the amount of wages that you pay taxes on. Then you also have a federal requirement to pay unemployment taxes, and that's 6% up to 7,000 in wages. And then DC has a very small administrative fee of 0.2%, so it's ultimately $18 an employee. Any questions on this one? Okay. So here's just a slide that shows you the reporting timeline. So basically, you have until the end of the month after the quarter ends to timely report. You start getting assessed penalties once you get into the second month after the quarter. That's when you'll start to see that 1.5% and then the 10% penalty. So stay in the white section, be mindful that you're going to start getting hit with penalties if you're filing late. Okay. Now, this actually should be another webinar that I think we should host, but ultimately, we now are in a world where people are often living in one place, working in another, or working from home. And so there's tests to determine where you should pay or sign up for unemployment taxes. And it's a 4-part test. I think some of this could be clarified because they slightly may conflict, I think, with other states, but you pay unemployment taxes only to one state for each employee. So the first test we're looking at is, where is the person's work localized? So DC is saying that if the work is localized in DC, so for instance, where they actually perform the work is in DC, then you would report wages to DC. If it's not localized to DC, then we go down to the second test, which is where is the base of operation? So for some jobs, people report to a home base and then they may go out into the field. So home care workers may have to come report to home office, check in, do time, and then they'll go out to their various jobs. So if the base operation is in DC, you would report to DC. If it's not, then we go to the third test. And that third test, I think where it gets a bit tricky, is where are the instructions directed from? So if, let's say, someone is working, the business is in DC, the managers are in DC, and they are giving out instructions for people that work from home that might live in Virginia, just across the bridge there. DC is saying if the instructions are coming out from DC, you should report to DC. Now, I think that's an area where you really want to seek individualized counsel, because I think the rules in other states might conflict with that. So that is an area that I really do think you should talk to your own individual attorney about where you should be filing or reporting unemployment wages to. And the last test is, none of those previous tests are met, then you look at where does the person reside. So if they live in DC, then you would pay unemployment taxes in DC. If they don't, then you don't pay unemployment taxes in DC. Questions, thoughts about this particular point? No? Okay. All right, let's just go over a tax example. So let's just assume the top wages for unemployment tax in DC is $9,000. So basically at 2.7%, that would mean $243 per year. And we're talking kind of a person that's employed annually would be paid to the state DC unemployment tax. And then another $420 would go to the federal government, and then the $18 administrative fees. So you're looking at a total of about $381 for unemployment taxes per employee in DC. Obviously, those rates change depending on what other states might apply. All right, so the rules get a little bit complicated in terms of what makes an employee eligible for unemployment. So first, this is probably going to come as a shock, but anyone that is either unemployed or working less than full time can technically file for unemployment. So that means your part-time employees, depending on if they meet the other eligibility requirements, could be working part-time but still apply for unemployment. So those are factors you need to kind of consider, especially in making your wage determinations for those employees. Also keeping in mind that DC has a minimum wage requirement. So for unemployment, the employee must have earned at least 1,300 in a particular quarter, and at least 1,950 for the total base period. So that means the 12 months prior to filing a claim. So at a minimum, they needed to have made 1,300 in a quarter, and also at least 1,950 in that 12-month period before they file their claim. Also, to be eligible, and this is where it gets a little complicated with some math, but the highest order of wages needs to be at least 1.5 times the total amount. of wages they received in the base period. So example, if an employee's total wages was $5,000, but the highest quarter that they earned wages was only $3,500, then that person would not be eligible for unemployment in DC because 1.5 times 3,500 is 5,250. And so their total wages did not equate to that 1.5 times the highest quarter of wages. So it gets real complicated with the math. So this is why, hiring someone else to do these calculations could be very beneficial. Again, the base period is just the 12 months before the person applies or files a claim for unemployment. And a benefit year is basically the 52 weeks to collect up to the max. And so the benefit amount is going to be 1/26 of the wages, and it's capped at $444 a week. Okay. So the employee will get the lesser of either 26 weeks of compensation or until they've received half of their total wages. So let's just kind of do some math with that. For example, an employee that makes $30,000 annually has basically a salary of $2,500 a month or $7,500 for a quarter. That person would be eligible because they've made more than $1,300 a quarter and their total wages for that 12-month period are more than $1,950. And also the total wages in a particular quarter are at least 1.5 times the highest quarter. So 1.5 times that 7,500 for the quarter is 11,250. If they made 30K for the year, that means 30K is higher than 1.5 times a particular quarter. Now, in terms of their benefit amount, what we would do is take their highest quarter of wages, so 7,500 divided by 26, and that will give them a weekly benefit of roughly $288.46 per week. And so because this person's weekly amount is relatively low, it's about half, they're going to likely get that full 26 weeks unless they get other employment, because 288 times 26 is not going to reach $15,000 or half of what their total wages were. Any questions? That's a lot that we just covered. No? Okay. All right. So what a lot of employers don't understand is that there are two agencies in DC that are involved with unemployment claims. The first step in the unemployment process is for a former employee to apply for unemployment with the Department of Employment Services. So you guys have probably seen this DOES. We call it DOES. It looks like DOES. But they are the first step for handling unemployment claims. And so the employee contacts DOES, they make a claim. And then what happens is DOES sends out notice and a request for information to the last known employer of that particular person, as well as every other employer in the base period. So for instance, let's say we had an individual that worked 6 months at one job and 6 months at the other. Both of those employers in that 12-month period are going to get notified that an unemployment claim has been filed. And I do believe that only the more recent employer is going to get a request for separation information. Typically, that is going to come from a database called SIDES. And so that is something that you should definitely register for as an employer, because you only have 7 days to respond to a request for separation of information. If that DOS does not hear from you, then by default, the person is going to get unemployment. And again, remember I talked earlier, there are certain potential penalties for not responding to requests for separation. So DOES considers 2 consecutive times of not responding as grounds to say, well, if you wrongly overpaid, that's too bad, because you should have answered when we asked you for the information. Okay, so that's the first step. And then what happens after the employer provides the information related to SIDES? Sometimes DOES reaches out to get the employee side, sometimes not. But in any event, DOES will then issue a determination letter, which basically is the agency's decision on whether or not the person is eligible and or qualified / disqualified to receive unemployment. Okay, so you should get a letter from the DOES, and this is where it gets tricky and people often kind of lose it on both sides, is be proactive. If you know that you have recently ended employment with someone, whether that's because they resigned or they were terminated, just be proactive. Check your account with DOES and see if any claims have been filed. And the tricky thing about it is I don't know that there's a time period or time limit on when the employee can file. So you kind of have to keep checking for that as an ongoing thing. All right, so after you get that determination letter, the next step will be whichever side is unhappy with the decision has the automatic right to appeal, but it must be done within 15 days from the date on that determination letter. So I know with a lot of us working from home, a lot of people are like, well, I didn't get the letter, but it's like it was mailed out to you. So sometimes you appeal to the Office of Administrative Hearings, which is a different agency in DC, is basically the court that oversees the administrative actions of DC government agencies. Okay, so it's different than DC Superior Court. This is the court that is reviewing what different DC government agencies are doing. So that's where workers' compensation is handled, unemployment. I can't remember the others right now, but basically they're reviewing the acts of the DC government, Office of Administrative Hearings. Okay, so you would apply to them. There's a website and you would submit if you are the employer and you do not agree with the determination letter. You would apply for an appeal, but you must do so within 15 days. And I'll tell you, the judges are getting more restrictive on that 15-day requirement. So please do be proactive. If you know there's a claim out there, be looking for that determination letter, ask for it so that you can file a timely appeal. And the reason why it's also significant is you have basically 2 weeks from the date that the appeal is filed until your hearing with the Office of Administrative Hearings, which is a very short time. And what ultimately happens is there's like a mini evidentiary hearing where we put forth witnesses, put forth evidence, etc. And so you really do have to act quickly because they're not like, oh, well, you didn't see it. Oh, that's too bad, right? Like it can become a big issue of not getting that. And then this is where I come in. So once you get that, scheduling order for the appeal, then you need to immediately reach out to the employer advocacy program because we've got a short time frame to get ready for this hearing. There's evidence that you want to submit has to be turned in 3 business days prior to the hearing. And that can really trip you up because we don't count weekends or holidays in that time frame. So you've got to be proactive and reaching out to get that free legal services help. And then what happens is you will appear before an administrative law judge. As the employer, you have the burden of proving that the person should be disqualified. And there are 2 grounds for disqualifying an employee from receiving unemployment. One is if they voluntarily left. And I'll just make a note here that if someone was told, hey, you need to quit or we're going to fire you, that will be considered still a discharge, even though the person, I guess, officially resigned. And the second is if the employee engaged in certain types of misconduct. So not doing their job well is not considered misconduct in DC. There is a statute that sets forth the types of actions that the employee must engage in for that to be considered misconduct. And then there are 2 types of misconduct. One is gross. So that's very egregious action that would be intentional. So think, fighting at work, substance abuse at work, excessive absences after being warned. Okay, and then your reason for being absent is not excusable. So you called in off of work multiple times so you could go on vacation. That's not going to be excusable absences. So those can be gross misconduct, which means the person gets absolutely no unemployment. The other type of misconduct is called other than gross. So this is where the person's actions do not rise to the level of seriousness as the other category, but it's still kind of contrary to the person's, to the employer's interest. So think of things like absences that are not, so many in number that it should be gross. For that, basically what happens is the employee only the length of time that they can receive unemployment benefits is shortened. So they still get some unemployment benefits, but it's less than the amount that they otherwise would have qualified for. Any questions? I know that's also a mouthful. No? Okay. All right, so let's summarize. Here's where I do need you to be proactive. So, true or false, unemployment punishes employers. Ebony, what's the answer to that? Ebony, you still with us?
Yes, I am. I'm sorry, I don't know the answer.
Uh-oh. Anybody else want to take a stab?
False?
That's right, false. Unemployment is not intended to punish employers, even though I know it can sometimes feel that way. It is a statutory right, and the employer's ability to succeed on these claims depends largely on their record keeping. Okay. All right. Can someone name 3 employer requirements? Give me one at least. Uh-oh, I'm gonna have to start this presentation all over. Registration, if you have at least 1 employee. Reporting, remember you've got to report those wages by certain deadlines. And the last is the paying taxes on those employees. And also reporting new hires, okay? What are the 2 now this one I'm gonna require you guys to actually answer. What are the 2 agencies that are involved in unemployment claims in the district?
One is does DOE
Does, that's right,
DOE.
yes,
And
DOES,
the
correct.
other
What's
one didn't have a fun acronym, but gosh, I remember the logo. I'm spacing on the name. I'm sorry, but I definitely it had that blue with the red. Like I remember the logo. I just can't get the name out.
It's OAH, Office of
Oh,
Administrative Hearing.
we need to get them a cool nickname like Does.
I know. Yes, exactly. Okay, good. And how many days do you have to respond to a request for separation information from DOES? Somebody new.
7.
7. Thank you very much. Please do be proactive with that. That is a very important part of the process. And then how many days do you have to appeal a determination from DOES, related to unemployment?
15.
15. Thank you. I gave you the answers right there. All right. So with that, I am pretty much done. Thank you so much for listening. I know it's not the most intriguing topic, but it's a very important topic in DC. There can be steep penalties to employers and not complying with the requirements and not challenging unemployment claims for which the person has engaged in misconduct or voluntarily left. So it can increase the more people that are paid out unemployment from your account, then the more likely you are to see an increase of the tax rate for all of your other employees. So this is actually really important work for a business to really take seriously and to be more proactive and take a look at. So if you have any questions, if you get an unemployment, determination letter, please do not wait. Reach out to us immediately. You can email us, and I prefer it to be email at eap@dcchamber.org. And then also stay tuned to the DC Chamber website, because we're going to have more webinar sessions related to unemployment in particular, but maybe sometimes broader employment issues within the district. With that, that's all I have. I'm happy to take any questions, hear any comments. I'd love to hear what other unemployment or employment related topics you all would like to hear more about.
Thank you so much. This was super helpful. It was a good overview of everything.
Good, thank you. Anyone else? Lucky, do we have online the DC Health Link, folks?
I do not see them on here.
Okay, so let's give it a few minutes. I do believe that DC Health Link is coming on to share some information. Let me send a message to see timing for that.
Hi, Taisha. DC Health League isn't joining, but I'm saying a couple of things on their behalf, if you're ready for me. All right. Well, I'm Ebony Johnson, and I'm here with the Chamber. The DC Chamber is a proud partner with the business community and the DC Health Link to ensure businesses are aware of affordable health insurances options that can offer employees through DC Health Link. It's a part of the Affordable Care Act. Right now, many individuals are rolling off of Medicaid, and that may include some of your employees. DC HealthLink is encouraging employees to register for a special enrollment period, which allows employees who are impacted by Medicaid unwinding to enroll in an affordable healthcare plan. If you're interested in learning more, please let us know in the chat or email us at info@dcchamber.org. And I'll put our email in the chat as well. Thank you.
Thank you, Ebony. All right, well, everyone, we'll end just a few minutes early here. Thank you so very much for coming and participating. And Lucky, I think that we're going to have this recorded and uploaded onto the EAP site at the DC Chamber, right?
Correct.
Okay. I'm happy to answer any questions. So again, please email me.
Thank you.
Thank you all. Good day.
Thank you, everybody.